Good afternoon, Your Honor. Don Silva on behalf of the people, PA 7439.
Nicholas Darren on behalf of the defendant, Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could unmute yourself, state your name for the record.
Very good.
Okay, got it.
You got it.
All right, you hear me?
Yep.
All right. So this is People versus Martin.
Yes, Your Honor. I have spoken with the complaining witness. At the time, he would like to proceed with this case, and the people would ask to set it for a settlement conference before we go forward with trial to see if there's a resolution.
All right. And Mr. Darren?
I mean, Your Honor, I guess we're going to proceed that way. I was hoping, I'll renew my motion from the last time. Mr. Martin's been incarcerated, I think it's like 62, 63 days now. Court rule is pretty clear. If he's in over 28 days, he should be released on a personal bond. Mr. Martin's just been sitting in jail on this matter. I mean, I guess from practical, I would imagine the court's going to give him credit for time served, regardless of what the resolution is on this matter. Considering he's done over, at this point, he's done over 2/3 of what his original sentence would be. We're not going to accept an offer on this, and I guess we'll just set it for a settlement conference then, if that's what sister counsel wants.
And Your Honor, it's I know this case has been going on for a while.
Personal bonds.
That's correct. The issue here is that him and the victim are brothers. They live at their family.
First, I want to deal with the whole bond thing, because his bond is $2,500 personal.
So I think the issue with that is I was having a cover last week, but per the notes, if you recall, you ordered him not to return back to the property because there's a no contact order in place. 2 weeks ago, when Mr. Brother Counsel appeared for the first time on this case, I believe I agree, and that's when the bond was changed. But Mr. Martin, Judge Kirsten, yes.
So Your Honor, Judge Kirsten changed his bond, and then after some further statements were made, he changed his ruling to leave Mr. Martin in jail.
And that's because Mr. Martin made comments about returning back to the location, the home where the victim lives. And to my knowledge, per my conversation with Mr. Martin, the victim today, he indicated he'll be leaving the hospital, returning to that house tomorrow.
Right. All right. So I'm going to.
I mean, I have no objection.
Mr. Martin, listen, you understand? I wasn't here, but Judge Kirsten, your original bond was $2,500 personal. Then he set it at $2,000 cash because of the alleged violation that says it says need to set a hearing on violation ASAP. I don't know if there was I don't see anything whether there's an alleged violation of the bond condition. Is that right?
Not an alleged violation. He made comments.
He made a comment about it.
That he'll return back to the house.
This is why something. All right. So you understand you can't go to that house while you're on that. That's one of the bond's in place. You understand that? Stay somewhere else. You understand that?
No, I do not understand, and I gotta stand up. First, I have nowhere else to go. Okay, so that's why I must return back there, and I objected. No, listen, let me talk. I objected to the bond conditions before. I'm objecting to them now.
Listen, your objection is duly noted. You have very, very highly competent counsel. So, let's let your counsel speak on your behalf. And so he already did. He made a motion.
Well, I object to him speaking on behalf of that.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days, and then you can just sit there anyway for it. Stop interrupting. Your Mr. Darren made a motion to set this for a personal bond. I'm going to set your bond at $2,500 personal. No contact with the victim or the victim's home location. And if you show up at that location and violate my bond, you could be held in contempt of court. Just want to make sure you understand that. I'm just telling you that right now. So I'm setting your bond at $2,500. I'm granting the defendant attorney's motion, and the bond's $2,500 personal. No contact with the victim. and no live in the state of Michigan without the consent of the court.
I got something to say.
And you have a right to remain silent, and anything you say can be used against you, and you already have an attorney who's talking on your behalf, and I've already granted his motion and changed the bond to personal, so.
Hey, well, I have something to say in response to that.
See everybody at trial.
I have something to say in response.
We'll see everybody at trial.
Your
Mr.
Honor,
Darren,
Something to say in response.
Mr. Darren, do you have anything else further?
Your Honor, are we gonna set it for a settlement conference, or are we just gonna set it straight for a trial?
Sure, I'll set it for a settlement conference, and then a week later it'll be the trial.
All right, Your Honor, I understand the court's position. I mean, if Mr. Martin wishes to make a statement on his behalf, I can only advise him that I wouldn't, but if Mr. Martin wishes to make a statement and the court wishes to hear it, I don't have any, I mean, I'm not gonna, I'm advising him not to say anything, but Mr. Martin, if the judge wants to hear it, if he's allowing it, then I'll step
Hey,
aside and let you state
Mr. Martin, I've already granted your attorney's motion to set the bond at $2,500 personal. So if you have some other statement you want to make, I'm just going to reassure you again that you have the right to remain silent. Plus, your attorney's already said that, hey, you know what, it's probably a good idea to just do so, but go ahead.
Yes. Like I said, I'm going to exercise my First Amendment right to speak, and I have a lot to say, so I ask that you don't cut me off or I'm done talking. Now, I object to the bond conditions and stuff. I can't be in my house. It violates my due process rights. I have nowhere else to go, and he's not the true victim. He's lying, saying he's a victim, but I told the cops when they arrested me that I was the victim. And so we have an equal protection clause violation.
All of that'll be the subject of the trial itself. So we'll hear everything you have to say about that at trial. Your objections duly noted. But it doesn't change my positions.
Take a seat
I have a question.
in this blue chair.
Do I have the
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down in that blue chair.
Do I have the
Sit down.
there?
One more time. Sit down. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs.
I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No,
Would you
I do
just-
not recognize
Well,
anyone in this court.
Okay, well,
I
that's
don't
too bad.
recognize you or the bailiff or anybody else in this court. Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis, non de guerre.
I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested. You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it? Court is now on the record in City of Conneaut versus Amber McHenry, 24 TRD 819. Ms. McHenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor, on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McHenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McHenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McHenry is now turning herself in on the warrant. She's in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR, like 0800 something, and
24 TRD 819.
819. Okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
I've never claimed.
Well, your documentation that you file, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official in this case who is acting as a public servant to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. I need the accounting. Please, for the record, let it be known that you exited.
I
while
did.
asking.
I exited the courtroom and asked a police officer, probation
Who has
officer.
the indemnity bond? Where is the bill of particulars?
The
Because
bond
I
is
did not receive it.
the warrant is being executed. You're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to
either.
the jail now.
Why am I being arrested?
Take her down
For
to the
what?
jail.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest.
Knock it off. Stop fighting.
No, this is a false arrest.
Knock it down. Just. Okay. Relax.
This is kidnapping. They're violating my rights, my constitutional rights. I put in,
I thought the Constitution didn't apply to you.
the Constitution applies to every living man and woman.
Yeah.
You are violating your oath, Mr. Iarochi.
Okay, we're going back to the trials now. Frederick Falcon versus James Larry Warnicki.
Give this to the judge, sir.
Mr. Falcon, this is your case. So what is it you're asking for the court?
We purchased a house through tax deed auction, and we're just asking occupants to vacate the property.
A tax foreclosure sale?
Yes, sir.
Okay, I see a copy of your sheriff's deed. You had it attached to the petition, and you purchased this on the first Tuesday of November, is that correct?
Yes, sir.
Okay, and after you purchased the property, I guess you realized it was occupied, and you served a notice to vacate. It says hand delivered.
Just let us know.
And by hand delivered, do you mean you actually handed it to him?
We tried to. There's a lot of signage up at the property. It's very intimidating. Gun, don't trespass, knocked on the door, left the letter.
Where did you leave it?
Front door.
It says hand delivered.
Yes, sir.
Okay, but you didn't hand it to anyone,
No one refused to answer.
sir?
No one answered. No one
No one
answered.
answered. So you just stuck the notice on the outside of the
Stuck
door,
in the door.
in the door. not on the inside of the,
Through the crack.
through the
Went
crack.
in the house, went in the house.
Okay, let me hear from you.
I never did see it,
Okay, but
but
what's your opposition to this eviction?
I've got an unrebutted affidavit I sent to the Albert Uresti tax assessor around 2021. He didn't rebut it. So an unrebutted affidavit, as far as I know, it's a maxim of law. It stands as the truth of the matter. The truth of the matter is I don't know property taxes because I declared my house private property.
Okay,
And private property is not subject to, only real estate is subject to income, property taxes. So that's what I couldn't understand, how they just went around an unrebutted affidavit like it was nothing.
okay. So what you have is an issue of title, and I don't have authority to hear any issues of title. Okay? Not within my jurisdiction. You'd have to do that in a different courtroom. Okay? But for today's purposes, you got very lucky because the way you serve the notice to vacate doesn't comply with Texas law. You can't just stick it in the door.
Okay.
You have to put it on the inside of the main entry door. You have to look at Texas Property Code,
What do we do?
Section 24.
What if we do if he's not answering or not?
Well, that's what I'm telling you. Either hire an attorney or read Texas Property Code Section 24, and it's very specific as to how the notice has to be delivered. Now, the law is clear. It has to be delivered in certain ways, but it doesn't say they have to actually receive it. Okay?
Yes, sir.
Because I've had people say, I emailed it. Well, that didn't count under the law. You know, there's ways you have to serve it. And based on your testimony as to how you served it, it's not one of the legal ways to serve the notice to vacate.
Would I be able to serve the notice now?
I can't give you legal advice. Okay. This case is going to be dismissed because the notice to vacate was not, properly served. And, you're going to have to start over. And so I would suggest we speak with an attorney about your title issue, if that's going to be your.
I've got another unrebutted affidavit here called the Executor's Entitlement Land Title, where I own the land
Okay.
under that
Again,
house.
I cannot determine who owns the land. I can only determine who has the superior right to immediate possession. That's the only issue before this court.
Well, hey,
That's the only issue I can address.
let me stop all this then. Let me just give him the house. I've already vacated. I've got another place to live. And I just want to settle this. After the reset that's coming up, we're going to have a global reset. I'm going to get the house back because I own the land.
Okay.
I'm a sovereign principal. I'm not a U.S. citizen. U.S. citizens can't own land.
Yes.
On a deed, a Texas deed, it says they're a tenant in peaceful possession. A renter, I'm not a renter. I own the land. And I don't own the house. He supposedly does because they just went around and my
Yes, sir.
affidavit like it didn't exist.
I have heard those arguments, sovereign
Hey.
citizen, multiple times.
No, sir. I didn't say sovereign citizen. I said a sovereign principal.
Sovereign
That's a big
principal.
difference.
Okay.
I'm indexed through the Universal World Court in Fort Worth, Texas, Judge Henderson. I can own land.
Okay. But those issues, I cannot hear those issues.
Okay.
This court
Well,
does not
can you
have
just give him the
jurisdiction.
house then?
So are we in judgment then if he's,
I can't give you a judgment because you didn't properly serve, but he's telling you he's surrendering the house. You give him the keys and that's official surrender of the house.
Okay.
Okay? And then you probably don't have to file anything. You don't have to come back. You're going to get your house.
I'm doing him a favor. I want to
Go
be
on.
done with this.
Yes,
I'm going to get the house back,
Okay.
after the reset.
Was trying to tell me this earlier. Mr. Lamech Thomas had an
Yes.
announcement to the court. I believe.
Yes, I would like that announcement. I was gonna ask. Go ahead.
All right, so I won't be needing an attorney. I'll be representing myself as my trust. I'll be representing my trust. I wouldn't need an attorney.
Okay, what you mean by your trust?
I'm sorry.
What you mean by your trust?
My name is trademark copyright. Representing my trust when they have.
What does all that mean legally? Do you even understand what you're talking about?
Yes, ma'am. No jurisdiction. I'm not under
No, ma'am. No, sir, Mr.
jurisdiction.
Thomas, no. No. We got a president with 37 felonies, sir. He was under somebody's jurisdiction. So I don't know how you, a black man born in America, thinks that you got some stuff that's going to keep you from being under somebody's jurisdiction. All this, I done trademark my name and it's, I'm not the true man and it's the paper man and all that foolishness, Mr. There's none of that works. None of that works. Y'all go on the internet and figure out some stuff that don't make a bit of sense. And then it hampers you because you think you know better than an attorney who's gone to school for 3 years and 4 years before that to go to college, and they figured out and then they worked. Mr. Lynch has been an attorney. I've known him for 10 years now, at least, right, Mr. Lynch? So, but you think
getting close.
you think you done gone online and found some stuff, and you the trust of the straw man of the sir. You don't even understand the American legal system and how it works. But you gonna make up your own stuff because somebody done told you that this works. Same person who told you it works, it don't work. Then what kills me is y'all do stuff like, oh, and under the UCC and the maritime, y'all start quoting stuff that doesn't mean anything. I had one guy in Atlanta tell me something was under maritime law. I was like, sir, we are not even near the ocean. Maritime law is for the ocean. It's the esoteric foolishness that y'all get because y'all have done your research. No professional. You over here talking about you the trust. Okay, imagine if you walked into a hospital and they told you you needed surgery and you said, oh, no, I'm the trust. I'm not the man. I'm going to do my own surgery because I looked it up online.
I'm not the trust. I'm representing the trust.
No, mister, you don't even know what that means. What I'm saying to you is professionals work for years to learn this, to be able to represent people. You wouldn't walk into a hospital if you had a stab wound or a gunshot wound and say, oh, no, the trust is going to take care of me. I'm going to do it myself because I did some research. I am so sick of y'all thinking that attorneys don't do anything. My mom is an attorney, and one of her clients said to her, well, all you really do is, they're trying not to pay her. All you really do is talk. I can talk. Yeah, but do you know the right words in the right sequence and the right things to look up to make the talk you do make sense? No, you do not. So if you think you can replace a lawyer, go replace a doctor. Next time you get sick, go break an arm and go set it yourself. Go let the true man set it. Go do that. So if you don't want Mr. Taylor to represent you, that's fine. You are free to represent yourself. I will give you the Ferrata warning as soon as possible. But what I'm telling you is there are problems that come with that because you may be hampered by the fact of what you don't know. The second thing is, don't expect that if it goes wrong for you, that you can then say, oh, well, I didn't have good assistance of counsel, because you are your own counsel and you've chosen that. And so just be clear. The third thing, I'm not going to listen to all this esoteric foolishness that you spouting off that you barely don't know. I'm going to follow the law that I studied and I've practiced for over, we rolling up on 30 years now. And so no, we're not doing this trust stuff, the true man, the UCC. We're not doing none of that. So when you come before me, I'm doing the law that I know it to be. I'm going to follow the statutes, the Constitution, and the case law before me that is good law in the state of Georgia and the United States. I'm not playing your game. So let me know. I want you to be clear that this is how this is going to go. We clear?
Yes, ma'am.
All right. So are you entering a not guilty plea and you intend to go to trial?
What are the charges? I wasn't read the charges when I came in here. I was skipped for some.
Yeah, actually you were, because you have traffic charges and then you have an obstruction charge. Case 2024CR02581, obstruction of an officer. That's the one where you've decided you do not want the assistance of an attorney. The next case is 2021CR04186, traffic violation, which is generally a red light violation. License, driving on a suspended or revoked license, count 2. No license, count 3. One of those will merge, so you won't face both of those because of the merger doctrine. So either you would have, if you were convicted, you would face either the driving on suspended or revoked license or the no license, not both. But those are the charges that are currently pending for you.
Okay.
All right, you're entering a not guilty plea and you wish to have a trial?
And those are together, or are they two different charges? Are those two different charges, or that's one whole docket?
You have two different cases.
Right.
The traffic offenses are on the 2021 CR 04186. The obstruction of an officer is on 2024 CR 02581.
Okay, and what are the possible outcomes for these pleas?
Possible outcome is on a misdemeanor offense, if you're convicted, the maximum penalty could be up to 12 months in jail, a $5,000 fine, or both per offense. So for each of the offenses, but with merger doctrine, you would have 1, 2, 3 possible 12-month sentences.
And
those could be, or fines. Those could be served concurrently, meaning at the same time, or consecutively, meaning that they would be one after the other. One ends, the other one would start.
All right, I did hear eligible for NOLO. I did hear that come about. So I'll see fit NOLO on the.
Okay, but Mr. Thomas, listen to me. If you're entering a plea of guilty or NOLO, we do a plea right now. If you're entering a plea of not guilty, that means you wish to have a trial at a later date. You can have a jury trial or a bench trial. If you want to do NOLO on your traffic offenses, that's fine. We can do that case now, and you can save the next case for a trial. But if you're entering a plea of NOLO and you want to do that on your traffic offenses, that's fine. We can do that now.
Yes, ma'am. I would like to enter NOLO traffic offenses and not guilty for the obstruction of officer. And by any chance, did that police report show up yet?
We're still calling on the police report, Your Honor.
Okay, so now that you're representing yourself, then you'll have to ask for the discovery and get that information through the Solicitor General's office. If you just write a note saying that you wish to have discovery on this case, then you drop that off at the office or mail it to them, and she'll give you all of the discovery so that you can be ready for trial. Okay?
So I go to the courthouse?
Yeah, you can do that. On the 3rd floor, the Solicitor General's office, and you want to give them a handwritten note. You don't have to type it up or nothing. You can handwrite it that says, I wish to have the discovery on case 2024 CR 02581. And then put your email address, your phone number, and your full address. And that way they can give it to you or tell you how best to get it.
Okay, and is there any way I could do that without showing up? Because I don't live anywhere like in that area.
You can contact the Solicitor General's office. So you would Google Clayton County Solicitor General, Charles Brooks. And if you call their office, they'll tell you who to contact to get that done.
Yes, ma'am.
All right, Mr. Thomas, did you wish to do the traffic court now? The traffic offenses now?
I believe so, yes, ma'am.
All right, so raise your right hand for me.
I'm not in the jurisdiction of a courthouse, ma'am.
Okay, the law has changed, which under COVID, which allowed us to do hearings by video. So as long as you are on video with me in the virtual courtroom, you're under the jurisdiction and we can do the plea. Did you wish to continue?
No, ma'am, because I'm not under the jurisdiction. I'm in the video because I don't really know how to work this virtual courtroom setup yet. But if I need to exit video to further more speech that I'm not in a jurisdiction, I can exit the video, not the chat.
Okay. Are you entering a plea of not guilty for this offense also?
For which one?
For the traffic offenses.
No, man, that'll be a NOLO for.
No, we're not doing a NOLO. If you're not willing to do the NOLO by video, then we're not doing the plea right now. You've seen this. You've seen the people come from the jail calendar, and there was even one person in the courtroom. You've been here the whole time, so you've seen how this works. Like I said, I'm not playing your game. Either we do the plea the way everybody else has done it, or
this isn't a game. Like I don't even do court. Like I just happen to get stopped a few times in trucks that aren't mine. So I somehow get entangled with the police and the court system, but this isn't my field. But like I was saying, like it's definitely possible to do a NOLO. I'm just not under your jurisdiction. I'm representing my trust. Like I don't know what I'm supposed to like. I do my research. I see laws. I see common laws.
okay, that is the last case. Mr. Morris will be reset to next week.
Yes, Mr.
And Your Honor, for clarity purposes, is Mr. Thomas's, is his traffic case being a not guilty as well? That way we know how to proceed on that one.
I'm gonna enter a not guilty on his behalf because I'm not doing the foolishness today.
Man, I asked that. I'm not pled. Like you don't plead on my behalf. I don't call
Mr. Thomas, that's fine. You can ask me anything you want to ask, but I'm done. I'm not doing this. You say you want to enter a NOLO plea. I tell you how to do it. You've seen other
from the bench?
you've seen other people do it, and you don't want to play the game. You don't want to follow the laws and the procedures as we have them. So I'm gonna do what I need to do, which is to enter a not guilty plea on your behalf. We'll put you on the trial calendar. Thank you, sir. You are done for today.